Before we get started with Life in the Tax Lane, a quick message for our fellow tax enthusiasts. Tax Update 2026 is back for its 42nd year with Cait, Joe, Hugh, and Kenneth covering the year's most important tax developments, including dividend refund changes, new bearer trust reporting requirements, increased CRA scrutiny, and much more. Plus, don't miss the new 2-hour Bearer Trust T3 reporting webinar that includes a brandable client letter. Visit videotax.com to learn more and register today. The following presentation has been prepared by the Video Tax News team for Canadian tax and financial professionals. Program recorded July 23rd, 2026. Enjoy.
Welcome to the August edition of Life in the Tax Lane. Hugh, it's here. We are in the heat of summer. How are you doing?
August of 2026 for those who are binge watching in the 2030s. And although you'd think it would be quiet with Parliament risen, the Department of Finance busily working on our fall budget, we still get a lot of information from all our other sources. And we got kind of an interesting, not quite tax issue out of the Alberta Court of King's Bench. The court issued what they referred to as the unusual step of written reasons on a pretty straightforward application to tell a large technology company to provide access to digital assets of a deceased individual to the representatives of the estate, presumably the executor. And he said, I'm doing this because I want executors to hand a copy of this to large technology companies who are balking at handing over that access without a specific court order. The court doesn't need to spend that time. Executors and administrators of estates don't need the hassle. And if these large technology companies are going to keep dragging their feet and forcing this through the court process, they shouldn't be surprised to see significant cost penalties. So for those not in Alberta, keep an eye open. Maybe you will see similar cases in your jurisdiction.
Another issue on the tech side of things, as financial service providers, accountants, other providers, we have a lot of our clients' information at our fingertips, and we're very concerned about the privacy of that information. CRA has those same issues. They're also concerned about the privacy of our clients' information, And recently, we had the Privacy Commissioner of Canada issuing a special report in Parliament looking at an investigation of confirmed data breaches at the CRA. And they've noted that going back to 2020, they found more than 42,000 data breaches. Now, I don't think that's a surprise. We've talked about that in the past. But what I found interesting about this special report were the recommendations that the Privacy Commissioner made to the CRA to better safeguard your information, my information, our clients' information. Now, one of the recommendations that they made to CRA that very well may impact our practice is that CRA update its e-filers screening process in the fall of 2026. So updated changes there. We'll see what comes out of it. One item that was specifically mentioned is that e-filers will be required to attest their awareness of and compliance with obligations to protect taxpayer information. So expanding that awareness out there. Privacy Commissioner also recommended that CRA review the effectiveness of their existing security controls, look at multi-factor authentication. Is it working? Is it doing what they're supposed to be doing? They also recommended that CRA review whether a zero trust approach is appropriate. And the whole concept here is don't trust anyone and always verify. And what I found interesting in the report was the kind of examples of things that we're thinking about under a zero trust approach. Looking at dynamic access to information determined by factors such as who's requesting access, what device, when, and whether the behaviors of this request is consistent with past behaviors. So just a couple examples of things the CRA is looking at to make sure that our data isn't leaked to fraudsters out there where their tools are really being honed and expanded by all of these AI tools and machine learning out there. So an interesting report by the Privacy Commission. We'll see what it means for us as practitioners.
Kate, it's so easy for us and our clients to forget when we're dealing with having to jump through some hoops to get access to taxpayer data online. anything that makes it easier for tax advisors also makes it easier for fraudsters. So I don't think we're going to be seeing a loosening of those regs anytime soon. Another privacy issue that CRA was dealing with fairly recently was Schedule 15 information with trust reporting. And they had concluded early on that if a trust return included all that data, but it wasn't required, they weren't allowed to keep it. So they had notifications on assessments that we didn't retain that Schedule 15 information. Maybe you'll have to file it in future years. The challenge is because it's not retained on CRA's systems. If in the following year we filed the return just checking off the box that said, this is already on your files, we provided it earlier, then CRA wouldn't see it on their files and they would start assessing penalties. CRA has recently come out and said, we reviewed this practice. We have concluded that information submitted voluntarily can be retained. So going forward, if you submit it, even if you weren't required to, it'll end up on our files. But if you submitted it with a 2023, 2024, maybe even a 2025 return, it may not be on our files. If you don't see the notice of assessment, maybe you want to assume they don't have it and check off, yes, this is the first time we're reporting this information, or the information has changed, rather than risk getting hit with a penalty. CRA acknowledged that they would consider taxpayer relief for those penalties, but you'd have to apply. It's not going to be blanket relief for every penalty.
Yeah, another real interesting development as these trust reporting rules are rolled out and we're seeing the impact of these rules. Another issue we wanted to talk about this month, continuing on previous themes, about the importance of keeping our rights, our clients' rights open where there's a dispute, to object, to fight, to protect our dispute resolution option. So in this case this month, we had an individual who was denied some benefits, and their next step in the dispute resolution process was to file an application for judicial review, basically ask the courts whether CRA's discretionary decision was reasonable or not. So that was the next step. But they decided rather than to do that, I'm going to contact my member of parliament. And we have seen taxpayers contacting their MP in very specific circumstances, and they have got traction and have got assistance. In this case, the taxpayer contacted their MP. The problem was it took too much time for the MP to get back to them. It took too long, that their right to file an application for judicial review had expired. When the MP contacted them, they couldn't help. MP can't help. Now our deadline has expired to file a judicial review. So what do? Well, we went to court to get an extension. And the court basically said, too bad, so sad. You could have filed an application on time, but you chose not to. That right expired. That's done. You're hooped. No relief there. So the bottom line here is, even if you are pursuing alternative resolutions for your tax dispute, keep those legislated rights open. Do not let them expire. Hugh, what else do we got today?
Cait, I think we've talked about that in the past, and exactly as you said, these deadlines are real. Often the court has no power to do anything if we miss them. Those forms need to get filed to keep dispute options open. Well, we had CRA release an updated version of a policy statement that I find is very counterintuitive as a tax practitioner. The question was, CRA, we missed some items on our GST return. We should just amend that, right? Because timing matters. CRA said, well, actually, you can ask for an adjustment, but we have discretion on whether or not to allow it. And generally, if all you're asking us to do is increase input tax credits, it's not offsetting an increase in tax, there's nothing else to fix, we're not going to do it. Why not? Well, because you can claim input tax credits quite legally, unlike income tax items missed, on a later return, generally up to 4 years past the date when it was actually incurred. So don't ask us to add it to an old return. Add it to your next filing.
Yeah, pretty interesting concept there. Like you said, Hugh, counterintuitive, at least to me. Next item here, we've talked about this in the past and the whole concept that your travel from your home to your place of employment to your work, that's all personal travel. That's a commute. We typically think about this as your 20-minute drive. If it's a personal commute, you can't claim those as deductible expenses. You can't be getting a non-taxable travel motor vehicle allowance. We had a court case here that said, no, I'm not dealing with a 20-minute commute. I'm dealing with a 5-hour commute. Do the rules change there? And the court said, no, it's the same rules. Home to office, whether it's 20 minutes or 5 hours, that is personal. You don't get any tax benefits there. That's all we have for today. Thank you for joining us, and see you next month.
The Video Tax News team has been providing Canadian accounting professionals with practical tax information for over 40 years. Subscribe to one of our tax newsletters or join us as we present live and pre-recorded seminars relating to both personal and corporate tax. For more information, go to videotax.com. The preceding information is for general informational purposes only and deals with dynamic, time-sensitive, and complex matters that may not apply to particular facts and circumstances. The information provided should not be relied upon as a substitute for specialized professional advice in connection with any particular matter. For more information, go to videotax.com/disclaimer. Copyright Video Tax News, Inc. 2026. All rights reserved.